Hi, and welcome to Hull and Hull TV. I'm Dana O'Brien, and I'm joined by Ian Hull and Suzana Popovic-Montag, partners at Hull and Hull LLP, an innovative law firm with offices in Toronto and Oakville that practice exclusively in estate, trust, and capacity litigation. Here at Hull and Hull TV, we're exploring the issues around estate planning that affect you. Ian and Suzana, estate litigation can be costly, both financially and emotionally. But there is another avenue besides the courtroom: alternative dispute resolution. Suzana, under what circumstances should alternative dispute resolution be considered?
Well, having seen the alternative, a heated courtroom brawl, I will oftentimes canvass with my clients during the course of the litigation at various times the importance of alternative dispute resolution mechanisms. There are many opportunities to have those discussions with our clients, and in my experience, an outcome to an estate matter that is resolved in this fashion is oftentimes more rewarding and also less expensive. Also, when you're dealing with mediations and arbitrations, you've got an element of privacy and confidentiality, which is something that's just not afforded by the legal system and the courtroom process.
Ian, how common is ADR in avoiding litigation?
Well, it's becoming more common. And I think in most of the major centers in Canada, it is one of the expected steps to take in any of the disputes that you're involved with in a courtroom setting. The alternative dispute resolution mechanism in estates, though, in particular, is a very, very important step to take because we're often dealing with people, we're dealing with emotions, and we're dealing with money. And that's not always well suited for a courtroom solution. So the alternative dispute resolution mechanisms, mediation, that sort of thing, gives a chance to be flexible and touch on issues allowing for better tax planning and those kinds of flexibilities that a courtroom just can't and a judge can't offer.
Suzana, how do you determine the most appropriate alternative dispute resolution process? What are the considerations?
Well, I usually start with the players who are involved, the individual litigants and their advisors or their lawyers. I also will consider the personalities, whether we're dealing with someone who's going to be possibly more reasonable and therefore an author of their own solution, or if we're dealing with intransigent parties who are really going to need a decision imposed upon them. I'm also informed by how they've conducted themselves during the course of the litigation itself and at what point in the litigation process we are, whether more towards the beginning, the middle, or the end. These kinds of factors are really things that we'll consider when we're trying to decide whether it's a mediation or an arbitration or a family meeting perhaps, or some hybrid of any of those that's the best solution for the parties.
And that brings me to my next question. Ian, what areas of law or processes are involved in alternative dispute resolution?
Well, it's a beautiful opportunity for people to resolve problems outside of the courtroom by virtue of the fact that almost all areas of law touch on it. And in estates, almost all areas of law touch on an estate. You could have a real estate problem, you could have a contract problem, you could have a dispute between executors. All of the types of problems and resolutions that the court will assist us in are touched upon in an estate environment, which is very attuned to the opportunity to give people in a mediation more flexibility. So you can sit in a mediation and hash out the real estate side of the problem, turn around and bring in some expertise to hash out the tax side of the problem, and put it all together to make a global resolution. And that is where the greatness of the process really comes to life, and why we encourage our clients most often to try at least going through the mediation, because of the flexibility.
Suzana, what are the most innovative steps or means of helping feuding parties come to terms?
I think two alternatives sort of come to mind, and they are actually both somewhat of a hybrid from more of the traditional ADR methods. One of them is med-arb, which is a combination of mediation and arbitration, where the parties will start with the mediation process and try to resolve as much as they can together. And when they can no longer make any further progress, then the arbitration part of it will kick in and an arbitrator will resolve the outstanding issues. The other one is collaborative law, which is a neat concept as well, where individual counsel is appointed for each of the parties, and there is no opportunity to go to court. So if they can't resolve their matter short of an actual court proceeding, then the collaborative process comes to an end, the lawyers can no longer act, and the parties actually have to retain new counsel and start all over again. So a little bit of an interesting kind of concept, a little bit outside the box, but certainly something that is working in some of the unique areas of law.
Interesting. Ian and Suzana, thank you. And thanks for joining us on Hull and Hull TV.